Bloomberg Audio Studios.
Podcasts, radio, news.
You're listening to the Bloomberg Balance of Power podcast. Catch us live weekdays at noon Eastern on Apple CarPlay and Android Auto with the Bloomberg Business app. Listen on demand wherever you get your podcasts or watch us live on YouTube.
A very happy Friday to you. That means there's about a week left in the Supreme Court's term, with a number of decisions yet to come down, but we did get a handful this morning, 5 in total, one particularly that was interesting. An 8-1 ruling in which the court upheld a federal law that bans those who have domestic violence restraining orders from owning a firearm. The court, interestingly, in this case, ruled that the Second Amendment is not so broad that it protects the gun rights of those who have been found dangerous. There was only one dissenter in this case, Justice Clarence Thomas. For more now, let's go to Jeanne Grasso, who is the host of Bloomberg Law. So, Jeanne, I wonder if you were surprised, if not by the ruling itself, by the fact that only one disagreed with it.
It wasn't really surprising after hearing the oral arguments in the case, and also the facts in this case were pretty egregious. It would have been hard to say that this man, Rahimi, it was all right for him to have a gun, because not only was there a domestic violence restraining order against him and he beat up his girlfriend, but he also on 5 different occasions fired a gun in public. He fired an AR-15, I think, into a neighbor's house. So, I mean, the facts were really bad for this case for gun rights enthusiasts. And so the court, during oral arguments, made it pretty clear that most of the justices were going to be on board with this particular restriction on gun rights.
Fascinating that they perhaps had an opportunity to read the Second Amendment in the broadest of terms and chose not to do so. We got a few other decisions as well this morning, June. In one case, the court said that federal courts cannot second-guess visa denials for spouses of American citizens, even if it means they can't live together in the United States. How does this interplay with the executive order that we got from President Biden earlier this week, allowing people who are married to U.S. citizens to stay in the U.S. to figure that process out?
It really doesn't intersect with it, because what President Biden's order is about is, in other words, in a normal case right now, if someone crosses the border illegally and then marries a U.S. citizen, in order to get citizenship, to get the papers moving, the process going, that person has to go back to his or her home country and apply from there. And people don't like to do that because it's very risky to do that, to go to, your consular office there. What the president's executive order said was those people, anyone who's married to a U.S. citizen can go through the process in this country. They can remain in this country while they go through the process. It didn't talk about the standard for getting, for being able to get a green card if you're married to a U.S. citizen. So I don't think it really, crosses each other. I think they're separate issues, but it's sort of coincidental that they came out in the same week.
Yeah, exactly. I think that's maybe why people who are less educated and legally minded, like yourself, like me,
No.
How do these things work together?
Well, it's odd because, for example, yesterday there were 3 cases having to do with minor sort of criminal procedure things. And you'd say, well, 3 cases together, that is odd. And I wonder, did the Chief Justice decide, all of a sudden he's going to group certain cases together? I mean, today, according to my count, there were 19 cases outstanding this morning. And I looked at them, 14 of them I considered controversial. And one of them was Rahimi. But the other 4 that came out today were among the non-controversial cases. So still the question, which I think we discussed the other day, is, what are they waiting for? There's a week left. They have only one opinion day scheduled for Wednesday. I assume there'll be more. But if at this rate, will they be able to finish by Friday, which is the usual time that they end?
Yeah, are we going to have to see opinion days added to get these other 14 rulings out, or are they just going to dump them on us all at once? And June, how do you think it factors into the court's mind that one of these days, next Thursday, is a presidential debate in which Donald Trump, who is a subject of one and kind of by extension two of these cases they have yet to decide. How does that factor into the court's decision on timing, do you think?
Well, it shouldn't factor in. It shouldn't have any bearing on, but does it? That's the question. And I've been talking to people because I'm always fascinated, and I don't believe in conspiracy theories, but it's odd that, at the end of each term for the last several years, we get all the controversial cases, basically all of them, in the last week, sometimes the last 2 days of opinions. So I do question why they haven't come out with those opinions yet, but I don't think that they're going to consider, the debate is tomorrow. For example, on Wednesday when they give out decisions, the debate is tomorrow, we should come out with this decision or not come out with this decision. I mean, it shouldn't be a factor at all, but it's just hard to know because the Supreme Court, there's no transparency. I mean, people have been saying this for so many years. We only find out about their workings when, for example, a justice, his or her papers are published years and years later. Mm-hmm. We find out about their workings, or from people who are behind the scenes and will, tell you what goes on. But I mean, it's not transparent, so we don't know what they're doing and how they're doing it and why they're taking so long to do it in this case.
Yeah, well, perhaps one reason is that while there's not transparency, there's not a ton of accountability either if you have a non-legally enforceable ethics code and lifetime appointments.
Not, some would say not any accountability because, as you put it, even the ethics code that they announced last year, we're having an ethics code and they published it and all this stuff.
Yeah.
But they're the ones that decide, each individual justice, whether or not they're following their ethics code. And that's why when we had the flap about Sam Alito's flags, the Chief Justice refused to get involved. He said it's for each individual justice to decide whether or not to recuse himself or herself. Yeah. So there is no accountability and almost no transparency.
All right, June Grasso, host of Bloomberg Law, thanks for helping us dissect the court and breaking down these cases for us. We appreciate it. We want to continue this conversation further now and bring in Robert McWhirter, who is a criminal and constitutional law attorney. Welcome back to Balance of Power, sir. Great to have you. If we could just begin with one of the rulings we did get from the court today, which I was just discussing with June, this 8-1 ruling upholding the federal ban on those under domestic violence restraining orders from owning a firearm. They made the decision here that the Second Amendment did not protect this person's rights because he was dangerous. Is that a proper constitutional reading?
Oh, absolutely. It most certainly is. This doesn't conform to Justice Clarence Thomas's view of the Second Amendment and the Constitution, but I think it conforms to what most people in America think and what most legal scholars think. And also there was a divergence of views because there was a lot of concurring opinions of the different justices explaining where they sit on this. And this is going to be a hot issue in other cases coming up. But this case really was the poster child for gun regulation. This is a person, Mr. Rami, who should never have a firearm in this context. And this statute was perfectly appropriate.
So are you surprised that the court could, by such a large majority, to uphold this and not uphold the ban on bump stocks? Just last week, they made that decision that essentially made that void. How does a reading of the Second Amendment factor into that decision differently than it did so in this case?
Well, it's a little hard to conform the two. I'll grant you that. Technically speaking, the bump stock case had to do with the appropriate scope of regulation and what an agency can do, in this case, the Alcohol, Tobacco, and Firearm Bureau, and whether they had the power to ban something or not versus Congress passing a statute. And in this case, this was an actual federal statute that was passed by Congress that banned people who have restraining orders from possessing a firearm. So you can make a technical distinction on that point. But other than that, Sure. It's a little hard. I also had reviewed the oral arguments, and looking where the justices came down, they all know that a violent person like this should not have a gun. Now, the court kind of left its declared methodology 2 years ago in a case called Braun, where they said you have to have an analog back from 1789 before you can have a gun regulation. And the Chief Justice kind of stretched that a little bit to say, yeah, they always prevented dangerous people from having guns and whatnot, and therefore that fits. And of course, Justice Thomas called the court out on that. I think that the court's decision in Braun is really a little absurd in the modern world. If you extend Braun as far as it could go, and as far as I think where Clarence Thomas would want to go, you could only regulate muskets and swords. And I don't think that's what the Constitution says or what it should say, but that's kind of where that is.
Of course, we're still waiting to hear where the court is on a number of 14, in fact, other rulings they have to make, including on Donald Trump's question of presidential immunity. I'm not sure when we'll get an answer on that. That, of course, is most applicable for the case brought against him here in Washington by special counsel Jack Smith. But Jack Smith brought a different case against Donald Trump as well, Robert, down in Florida, where Judge Aileen Cannon is presiding over it, the documents case. And today, Judge Cannon is holding the first in what's going to be a multi-day hearing looking into a question Trump has raised, an argument that Jack Smith was unlawfully appointed as a special counsel. Is there any legal bearing to that argument? And if not, why is there a 3-day hearing being held on it?
Well, that's the open question. Why is there a hearing like this on an argument that should not get that much attention? That's not to say that Judge Cannon may not grant Trump what he wants. Realize this whole argument was raised during the appointment of Robert Mueller years ago, and it's been floated around in certain conservative legal circles as a potential argument. It's a pretty weak argument. I mean, the essence of the argument is that anybody appointed to prosecute cases like this has to have some kind of review by Congress and appointed by the Senate or confirmed by the Senate, et cetera, et cetera. And that's just absurd. I mean, there are hundreds of prosecutors, if not thousands, appointed by the Attorney General, in this case, Merrick Garland, to fulfill the jobs of prosecuting federal cases. And this just happens to be a special prosecutor. And the argument that it has to have some special kind of incantation before the Attorney General can appoint a special prosecutor is, I think, simply a weak argument. The fact that Judge Cannon is given it this amount of time shows that she's slow walking the entire case, and she's doing something even extraordinary. Look, you raise a legal argument in a criminal trial, which I've done thousands of times in my career. You go in and you argue the case, and the prosecutor argues against it, one side and the other. She has invited independent groups to come in and present arguments on this question, which is going to extend this thing for days, when it should be a simple decision on her part that she should actually just read the pleadings and deny it. But this is going to extend it, which, quite frankly, is exactly what Donald Trump wants. He just wants this continued. He thinks he becomes president of the United States, and he just fires Jack Smith and the whole thing goes away.
So it all becomes a question of the timeline. And given you just said that Aileen Cannon in your mind is slow walking this, it also raises the question, though, of if Jack Smith, too, moved too slowly, both in that case in Florida and the case here in Washington. Did he just bring them too late, too close for the election, that there was too much margin for error on that timeline?
Oh, absolutely not. I think Jack Smith prepared a careful indictment after doing careful investigation. There was plenty of time to have tried these cases. And in fact, this case should have gone to trial months ago, but for Judge Cannon's agreeing to give massive hearings to what are throwaway issues from the defense. If it wasn't for the judge delaying this case would have already been tried, as would the other. So really, I think this is just all on the judge. I think this is a judge who is not fair, and she has shown herself to be in above her head. And so she's having all these long arguments, et cetera. In this case, certainly could have brought. I have tried more complicated cases than these, which have gone to trial within a few weeks or months and not have to have this absurd delay that basically gives the defense exactly what the defense wants. Not a win, but a delay.
Robert, we just have about a minute left, but should this case have been brought in Washington rather than in Florida?
Well, I'm guessing a lot of people on the Smith team are thinking exactly that. The general custom is that you bring the case in the situs where the event occurred, but there is federal jurisdiction, especially because of the nature of these documents being of national scope, that he could have brought them in the District of Columbia or in other districts adjacent or various other parts because of the national nature. Yes, he could have done that. And he may be thinking he should have done it, but this is the case we have, and this is the judge that we're stuck with.
Yep, too late now. Robert McWhirter, criminal and constitutional law attorney, thank you so much, as always, for joining us here on Balance of Power. We appreciate it. And of course, while all of these different legal challenges for Donald Trump continue to play out, they do so in the context of an ongoing presidential campaign. And yet Donald Trump is making a lot of money off these legal issues, his conviction netting him a nice fundraising haul in the month of May. And Joe Biden's is not looking as strong in comparison.
You're listening to the Bloomberg Balance of Power podcast. Catch us live weekdays at noon Eastern on Apple CarPlay and Android Auto with the Bloomberg Business app. You can also listen live on Amazon Alexa from our flagship New York station. Just say, Alexa, play Bloomberg 1130.
We've got fresh figures from the Federal Election Commission, and what a story those numbers tell. This is for the month of May, and there was a wide fundraising gap between Joe Biden and Donald Trump. For his part, Biden, together with the DNC, raised $85 million last month, while Trump and the RNC, powered in part by a galvanizing of his base after his criminal conviction in New York last month, pulled in a significantly more robust $141 million. So here with more on the numbers and their significance is Bloomberg's Gregory Korte. He is Bloomberg's senior White House and politics correspondent, joining me here in our DC studio. So Gregory, obviously, if you're the Biden campaign, $85 million isn't a small amount. In fact, it's actually significantly larger than they raised in April. It's just that it's smaller than Trump. So what happens if this begins to establish a pattern that's a reverse of what we'd seen so far this cycle? Biden outraising Trump. Now it's the other way around.
Yeah, 2 months ago, I think you and I were sitting here and we were talking about how, it was Trump who had all the fundraising problems. He had been reliant on small dollar donors. He had squeezed all the blood he could out of that turnip. We were talking about donor fatigue. People just can't keep giving Trump money, whereas Biden was doing pretty well among those small dollar donors and among the big donors as well. And boy, 2 months later, it does look like we're looking at the mirror image of that. And what changed, as you point out, I think certainly, and we've seen this all along, Trump's legal issues have become a galvanizing force for his supporters. So if you're Joe Biden and you've lost the fundraising race 2 consecutive months, now you got to be looking towards June and July when former President Trump is going to go back to that courtroom again to be sentenced. And you kind of have to think the more severe the sentence, the better the fundraising bonanza it's going to be for Donald Trump. Yeah. And now we're talking about a whole new ballgame in terms of the ability to raise and spend money. Yeah.
Do you see something in July 11th and the 48 hours after, like we saw at the end of May with that conviction? Also keeping in mind that immediately following is the RNC, something that also could be a galvanizing force. You mentioned, though, this idea that there is a difference between those grassroots, small dollar donors and the big guys, the big fish, the billionaires, who we also like to pay a lot of attention to here at Bloomberg. All the billionaires that seem to be on the sidelines, not really willing to throw in for Donald Trump, no longer seem to have as many reservations, and they're starting to put money in the pot.
Yeah, we saw this during the primaries where a lot of those names were looking for some kind of alternative, a more business-friendly face on Trumpism, somebody who could beat Joe Biden. Certainly, there's not a whole lot of love for Joe Biden's economic policies and his tax policies on Wall Street. He's talking about a billionaire tax, right? And so, but they were looking for somebody who they thought could beat Biden and maybe was a little bit more, spoke their language, right? That ship has sailed. Right? Trump is going to be the nominee at the convention in Milwaukee next month, barring some completely unforeseen circumstance. And so, yeah, they're rallying around the guy that they think can beat Biden, as flawed as they perceive him to be.
Of course, raising money from wherever you do is one thing. Spending it is something else. How are we likely to see spending behavior change for both campaigns, given the fundraising trends that we're seeing?
Yeah, I'm going to be looking very closely at Trump's spending in the next few weeks, because one of the things we've seen is, Biden has been out there. Biden and the Democrats have been on TV in all or most of the swing states, especially Pennsylvania, for the past few months. They've actually longer than that. The beginning of last year, they were up in the air on a lot of these swing states. Trump was on the air during the Republican primaries in Iowa, in New Hampshire, in South Carolina. After South Carolina, he clinched the nomination. We didn't really hear from him. And he has not really cut a new ad anywhere that we've seen on TV since then. Biden has continued not only to advertise in real time, but also to reserve time in September and October. That's going to be very important as we get to those last weeks of the campaign, because there's going to be a real scarcity of ad time to be bought. And so campaigns generally like to get that time reserved and booked and put down their deposit well in advance to make sure that they can be on the air, because in a state like Nevada, you will not see a non-political ad in the month of October. Car dealers, mattress companies won't be able to buy a spot because it's just going to be so jam-packed with political ads. And so we need to start watching to see who starts to put their markers down.
It raises the question, though, of what it's all worth. Why even spend the money on the ads when these are two candidates who have probably as close to perfection in terms of name ID as any two before them? It's a former president and a current president, right? You don't need to buy the name ID. So what can you buy if not that?
That's a really, really good point, Kailey. And not only is this going to be the most expensive election campaign ever, but we could probably expect it to be the most negative ever. And it's precisely because of what you're talking about. It's not just about defining your opponent, but because these guys are so well known, there's not a whole lot new that you can say about Trump's policies or Biden's policies that's going to move the needle here. The ads have to be that the other candidate is completely disqualified, right? Biden because of his age, Trump because of his criminal convictions. And that's what we're going to be hearing about from now until November, because it's not these aren't comparison ads. These aren't, well, this guy is marginally better than the other on this policy or on this character attribute. It's that this guy we cannot trust this guy to run the country.
And certainly after Donald Trump's conviction, you saw the Biden campaign almost immediately rolling out an ad that calls into focus the idea that Donald Trump is a convicted felon. So immediately trying to capitalize on it. Going to be really negative, to your point, Gregory Korte, Bloomberg senior White House and politics correspondent, rather. Thank you so much for joining me in studio. Now, some other messaging we have seen from the Biden campaign thus far not only surrounds Donald Trump being unqualified for office, but the idea that if Trump is reelected or gets a second turn at the White House, he also would have the power to potentially nominate more conservative Supreme Court justices. And the Supreme Court certainly is in focus as we are in the final stretch here of this term. Just 1 week to go, 14 opinions that they still have to hand down, and they did drop 5 today. One of them, particularly interesting, an 8-1 decision to uphold the ban on a federal law that bars people under domestic violence restraining orders from owning a firearm. So we want to get more on this case and the cases that we have yet to get a ruling on, and bring in Elizabeth Wydra. She is president of the Constitutional Accountability Center and a Supreme Court litigator. Elizabeth, welcome back to Balance of Power. Great to have you here on Bloomberg TV and radio. What the court decided in this gun case specifically was that there isn't a way to read the Second Amendment so broadly to allow for someone who has been found to be dangerous to own a gun. Is that constitutionally sound?
Absolutely. So, as you noted, the case was 8-1. Only Justice Thomas dissented, and that really shows the soundness of the constitutional analysis finding this regulation of domestic abusers to be constitutional, and also just the common sense behind it. You know, the Second Amendment obviously states a constitutional right. The Supreme Court has held that right is not unlimited. And although the Supreme Court 2 years ago in a case out of New York called Bruin said that there had to be some sort of historical similarity in order for a present day gun regulation to pass constitutional muster, there didn't need to be an exact historical twin. And Chief Justice Roberts, in the opinion that was released today, said that in that Bruin decision from 2 years ago, they weren't trying to create a law trapped in amber. that there could be circumstances when there wasn't an exact historical twin, like in this case with domestic abusers. And that didn't mean that the law must be struck down. If it fit with the purposes and the traditions that went into firearm regulation at the time of the founding and the drafting of the Second Amendment, then it could be constitutional. And here the court said, yes, this restriction on domestic abusers having firearms is constitutional under the Second Amendment.
Elizabeth, surely there are people out there who may just have some questions around the idea that the court could rule this way by such a wide majority, as we've pointed out, 8-1, on a case involving guns, having just last week shot down the federal ban on bump stocks. And if all of this surrounds the idea of danger, something that could be attached to a weapon, making it more dangerous, how are these cases so separate, if you will, that the court could rule so differently on each of them?
Well, that's a really good question. And I think that it's correct for the American people to be watching the Supreme Court and scratching their heads a little bit. You know, I think that there should be no mistake. This court and its very conservative majority has been very pro Second Amendment, has looked extremely skeptically on gun regulations. And we saw that in the bump stock case, where, you know, if you read the dissents of the more liberal justices, common sense would seem to suggest a different ruling in that case, as well as an analysis of the text and history of the relevant provisions. You know, I think what makes the case today about domestic abusers different is that it is such an extreme argument. You know, you have a person who is subject to a domestic violence restraining order, who has been found to pose a physical threat to another person and therefore is going to be disarmed under that restraining order. You know, this is a very extreme case of someone seeking to or presenting a clear threat of physical harm, and that's why the gun can be taken away or the firearms can be taken away. And the court today looked through historical analogs that showed that when there's a clear threat of physical violence, people can be disarmed, consistent with the right to keep and bear arms. One thing I thought was interesting that Justice Sotomayor noted in her concurring opinion, she agreed with the majority, but also wrote to separately say, you know, part of the reason why you don't want to look for a historical twin back to the 1700s is that, you know, there are differences, importantly, in how society has evolved today. In fact, if you look to the time of the founding, you're probably much more likely to find legal protections for spouses who abuse their wives and not accountability. Yeah. And so the fact that today the court said, look, we're looking at the principles, we're looking at the reasons behind why the Second Amendment could be consistent with disarming a person who poses a threat, that's the key point.
Well, there's also the question of the court having to rule on situations for which there is no historical precedent, like a former president being accused of many felonies and claiming presidential immunity. That is a decision we have yet to get out of this court. They need to do so within the next week, Elizabeth. And it's raised a lot of questions for people about timing, knowing that the ability for this particular case here in Washington to go to trial before the election in November really does hinge on an outcome here for the Supreme Court. What do you make of the idea that we've waited so long to get an answer and we'll wait at least days more still?
The timing is absolutely key for this decision. You know, the court could have taken the issue up earlier. Jack Smith, representing the United States in his role as special counsel, brought it to the court earlier, saying, please rule on this so we can move forward with our case in the interest of justice and the American people can have some resolution before the election in the interest of democracy. The court said, no, we want to wait. Then the court did take up the case. They scheduled expedited argument date, and then we've waited. And it seemed from the oral argument and just from the weight of the scholarship and the legal precedent that President Trump's immunity arguments will fail as a substantive matter. They're extraordinary arguments that would place him above the law in a way that has never been before countenanced in our American legal system and constitutional democracy. So the fact that the court hasn't issued that decision, it could basically give former President Trump a win through timing, even if he doesn't get a win on the merits.
Of course, you raised special counsel Jack Smith. He not only brought that case against Trump here in Washington, he also brought the case down in Florida, the documents case. And in Florida today, Elizabeth, before we let you go, Judge Aileen Cannon is holding the first in what is going to be multiple days of hearings related to an argument that Trump and his defense have brought that special counsel Jack Smith was unlawfully appointed as such. Is there any reading of the law that would suggest that he was not appointed in accordance with it?
I think this is a desperate attempt by the Trump legal team to, again, create more delays, although it seems like that case is perpetually delayed. There's really no there in that case. I think a lot of what he's doing with some of his legal strategy is, again, these delay tactics, which, frankly, have been fairly successful for him in running out the clock in other cases.
And of course, Judge Aileen Cannon, we should point out, was a Trump appointee, just as there are multiple justices sitting on the Supreme Court who are Trump appointees. When you look at the delay in that case in Florida, when you look at the delay all the way up to the highest court in the land, Elizabeth, should people not feel that courts are political, even if they're not supposed to be? Or is it impossible to separate the two in the modern day?
I think it is getting increasingly difficult for the American people to separate politics from justice. And that is deeply unfortunate, because it's really important for the judiciary to have the faith and trust from the people that there will be impartial justice, that there will be equal justice under the law for all, regardless of whether you're the most powerful or the most vulnerable. And I think we saw the American public's faith in the court plummet with the Dobbs decision overruling Roe versus Wade. And a lot of these delays, I think, in this Trump case are not really helping build back trust in the court, as well as some of the ethics potential violations that have been in the news, and the court's continued refusal to enact a binding code of ethics. They have a voluntary code of ethics that was put in place this term, but doesn't really seem to be giving the public much more confidence in the court. So there is a real crisis of confidence in the court, and it's extremely troubling. All
right, Elizabeth Wydra, Constitutional Accountability Center President and Supreme Court litigator, thank you for joining us here on Balance of Power.
You're listening to the Bloomberg Balance of Power podcast. Catch us live weekdays at noon Eastern on Apple CarPlay and Android Auto with the Bloomberg Business app. Listen on demand wherever you get your podcasts, or watch us live on YouTube.
So we have the May fundraising figures from the FEC. They've hit in the last 24 hours. And this is the money game in the presidential election cycle that could ultimately help decide its outcome. In the month of May, Donald Trump outraised Biden again. This is the second month in a row that it has happened, after the reverse being true for basically the duration of the cycle through April. In May, Donald Trump and the RNC pulled in $141 million. A lot of that came after Donald Trump's criminal conviction in New York on 34 felony counts of falsifying business records. For Biden and the DNC, they raked in $85 million. Not a small amount, but still more than $50 million less than what Trump and Republicans could do. So let's get right to it with our political panel. Rick Davis, Stonecourt Capital partner, is with me, and Jeanne Sheehan Zaino. She is Senior Democracy Fellow with the Center for the Study of the Presidency and Congress, our signature political panel on this Friday. So Jeanne, first to you, if you were inside the Biden campaign, are you panicking at these numbers right now and the cash cushion dwindling rapidly?
It's certainly not the trajectory you want to go in for the second month. But if we put it in perspective, they say they've raised about $558 million in this cycle. That is record breaking for Democrats. So they are both taking in big money. But I do think it is a wake up call for the Democratic team, and the reality of the fact that for all those on the left who thought that a convicted felon could not lead the opposition party. And these types of numbers, both the fundraising and the polls, quite frankly, are giving lie to that. So this is a wake-up call for Democrats. That said, they've raised a lot of money and they will keep doing that. And maybe given the last 2 months, they'll raise even more. And also importantly, they've raised small dollar numbers over what Donald Trump has done, who's raising from million and billionaires.
Yeah, it's a really good point. You're seeing the big money coming in a more material way. But of course, when we're considering what happened that month, again, a lot of this came after his conviction in New York. In fact, there was one donor who gave $50 million to the MAGA super PAC after that happened. It raises the question of whether or not the Trump team can repeat this performance in the absence of another conviction. Or is this really an event-driven campaign fundraising effort, if that makes sense?
Well, all campaigns use events to maximize their fundraising, especially small dollar donors who don't really pay any attention to it unless there's something big happening like a conviction. But I would say that the way I read these numbers is the big dollar donors are the ones really dominating the news. It's not the small dollar donors. I mean, when one person, donor Mellon, can give $50 million to Donald Trump, I mean, if you back that number out of it, it's basically they've raised the same amount. So it's really what you do with the money that I think is more interesting right now, because there is a significant diversion of strategy here, and that is Joe Biden's been putting his money on TV in the key swing states and sending out messages. Most recently, attacks on Donald Trump, which he hadn't been doing in the spring or early winter. And Donald Trump isn't doing any advertising. And we know he's got bills to pay for with lawyers. But when does he get in the game? When does he start placing bets? Even the Biden-associated super PAC has already reserved $250 million in TV time for the fall campaign. These are really important indications of the strategy to come. And I think the real pressure is on Trump right now to say, okay, you have resources. What are you going to do with them? Because he has got declining poll numbers, and there's going to be more pressure in the Republican Party to say, why aren't you engaging? Why aren't you advertising?
But to your point on the Biden camp having bought up so much ad space in the fall, is it more prudent in your mind as a campaign manager to sit on the cash and wait to spend it later, or to start spending it now when it's June and the election's not till November?
Yeah, you don't make up much ground in the summer. So husbanding your resources today is a good strategy. You're going to get a big bump at the debates next week. You know, all of America will zone in and see what's going on. You don't have to pay for that. You might want to buy some afterwards to sort of manage expectations. But then you have a convention in August if you're Democrats, in July and Republicans, and you don't have to pay money for that. That's going to be an enormous amount. 50, 60, 80 million people will watch that. And so you're really down to September, right? And so I think what I would be doing and what I've done in the past is you start husbanding your resources now and you start putting them on availabilities. TV isn't equal. It gets bought up first come, first serve. If you wait too long, and this would be my admonition to the Trump campaign, if you wait too long to get those avails, you're not going to get good slots to advertise.
It also raises the question of the content of those advertisements, Jeanne, just not how frequently or in what time slots that they run. We were speaking with Bloomberg's Gregory Korte about this earlier this hour, this notion that because these candidates are so well known, a former president and a current president, it's not about name recognition or even necessarily about their policy, because in large part that's well known as well. He said the way in which the American public knows these candidates suggests that actually what the candidates are likely to be putting out there is just a lot of negativity, attack ads. Jeanne, is that what you're bracing for as well?
Yes, and that is what is going to happen, because when you've got name recognition of this level, it is not a question of do people need to figure out who Joe Biden and Donald Trump are. And with such unpopular candidates, it is really more of an issue of defining the other. And so we are going to see that in all of these ads. We will certainly see that or an attempt to see that in the debate. And, it's been a campaign where you go across the board. It often doesn't matter what they're saying policy-wise. It's more about how they are presenting themselves and defining the other. And so in Joe Biden's, a week from today, or a week from yesterday, rather, on the debate, it's not going to be what he says, but how he says it. He's got to show he's strong, and he's got to make Trump look crazy. And that is what we're going to see across the board in this messaging, not what they say, but how they say it and how they define their opponent.
Well, Rick, we know that Biden is at Camp David right now trying to hone that messaging. But if all of this is about energy, what's the point of going through the whole exercise of answering policy questions or preparing your one-liners when people are just trying to see if your eyes are still wide open?
Well, I think for Biden, it is a test to see, whether or not he actually can talk articulately, even about the policies of his own administration. So he does have a bar to get over there. But I think, you and Jeanne are both right. I think that this is a race to the bottom. And Joe Biden wasn't attacking Donald Trump until recently. Why? Nobody can tell. His numbers didn't go up when he talked about himself. People think he's too old, and people think Donald Trump's too corrupt. So the difference there is, I think Donald Trump does spend quite a bit of time attacking Joe Biden, but he also attacks everybody else. I mean, it's a complete waste of his attacks to go after judges and prosecutors and things like that, because they're not on the ballot. Joe Biden's on the ballot. And so I think both campaigns are really dispersed in their messaging, much more so than any other presidential campaign I've ever seen. My question is, when are they going to narrow it down to one another, and what are those attack lines going to be?
Well, it's also interesting that as Rick talks about the various people that Donald Trump attacks at his various appearances, we are going to see and hear from Donald Trump this week, Jeanne. While Biden is at Camp David, doing his much more formulaic, we understand, debate prep, essentially shielded from the public eye, potentially until debate day, Donald Trump's going to be in Pennsylvania this weekend. Is it a mistake for President Biden not also to be visible, not just on debate night, but in the lead up to it?
I am one who thinks he's got to be out as much as possible. That said, the debate prep time, the rest, the ability to take a step back and think is critically important. He has been traveling around the country and obviously around the world in the last few weeks. So I think these days of rest and practice and rehearsal are important for Biden. But that said, after this debate on Thursday, he's got to get out there as much as possible. And, we can't forget, this is not only about the few hours or the 90 minutes they're in that debate. It's the spin afterwards. And it is brutal now because it is online. So we're really looking at a debate about editors in a way that we didn't used to 20 years ago versus just what happens during the debate. So he's got to be out there. If he doesn't do well on Thursday, making sure he can give lie to those attacks that are sure to come.
Yeah, it's just as much about Friday. Friday, we understand, according to CBS, Rick, Donald Trump is going to be in Virginia. Where should Joe Biden go the day after?
Yeah, I think Joe Biden needs to stay in the swing states where, he has a chance to win. And obviously the top tier priority of the blue wall, Michigan, Pennsylvania, and Wisconsin. He wins those three. He's president of the United States, I guess, along with Nebraska's 2nd district. So maybe he goes to Nebraska's 2nd district.
All right. I guess there's our answer. Of course, Rick and Jeanne, our signature political panel, always round things out for us on a Friday, in which we're now just 6 days away from that debate. Rick Davis is a partner at Stonecourt Capital. Jeanne Sheehan Zaino, a senior democracy fellow at the Study for the Presidency and Congress. Great to have you here on this Friday as we look ahead to the debate.
You're listening to the Bloomberg Balance of Power podcast. Catch us live weekdays at noon Eastern on Apple CarPlay and Android Auto with the Bloomberg Business app. You can also listen live on Amazon Alexa from our flagship New York station. Just say, Alexa, play Bloomberg 1130.
Counting down the days to the first presidential debate. There's only 6 of them left before that debate takes place on Thursday, June 27th. And if you're wondering, yes, that is unusually early for a debate to happen in an election cycle. It's actually happening before either Donald Trump or Joe Biden are actually the nominees for their respective parties. They're still just going to be presumptive at this point because the conventions haven't happened yet. And that's not the only thing that's going to make this upcoming debate unusual. There's also the consideration of the rules, like a mute button and no live audience. So we wanted to get some historical perspective and bring in Barbara Perry, from the University of Virginia, where she is a professor in presidential studies at UVA's Miller Center. Welcome back to Balance of Power, Barbara. Always great to have you on the program. Can we just start with the timing? Are people even prone to pay attention to a debate like this early in a cycle?
Yeah, I'm skeptical, Kailey. People, I've just come back from a bit of a holiday myself and took a little bit of a break from reading and watching lots of media and doing media. But first of all, happy to be with you. And second, it is summertime, and it'll be the height of the summertime. So I'm a little bit skeptical that as many people will watch as they would at, let's say, after Labor Day, as we get closer to the election. And I think the other element, though, that could go in the favor of a high audience would be the heat dome. Should that continue, and it looks to be the case across the country, lots of people will be at home. They'll be in their air conditioning, and they may be prone then to watch.
It's fascinating. People just trying to stay indoors, maybe looking for something to do as an added element that could factor in here. But there's also the question of what those people are going to be experiencing when they're at home watching this on television with no cues from a live audience. Usually at a debate like this, you hear the claps or the boos, whatever, in response to what a candidate is saying. The audience at home is going to be kind of left for themselves to decide what the reaction should be, because that isn't going to be there for the first time in what is a really long time, I understand, Barbara. How should we be thinking about the live audience and the lack of it more specifically?
I, for one, Kailey, will be pleased not to have the booing and the shouting and the clapping. I find that distracting. But it might be a little bit like during the pandemic, watching the U.S. Open tennis match or watching the Masters without anybody there spectating and cheering. And so the silence may be deafening in that sense. But I should tell you, I was just visiting with a young friend in my hometown of Louisville, Kentucky last week, and he's going to have all of his friends over to have a debate party. And they also have a pool, so it'll maybe be watching while in the pool. But he's going to have bingo cards. And he said, what could I have on the bingo card? What will these people be saying on the stage that is typical? And then, do you get to fill in your bingo card and yell bingo? So I think if people turn it into, I said, you're not going to do a drinking game, I hope. And he said, no, we're not going to do that. So I think there are different ways to watch. And maybe it will be like, I know when I watch college basketball, I am cheering and shouting and booing and jumping up and down. So maybe people will get into it at home.
Kentucky, home of not just derby parties, but I guess debate parties as well, Barbara. As we consider the idea of no live audience, though, and what that brings, perhaps more focus to your point, it's the absence of distraction. It's not just the lack of live audience, which we know that Donald Trump typically likes. He feeds off that energy. It's also the factor of the mute button, being cut off when your time is up, not having the ability to speak over the other candidate. Knowing what we know about these presidents, who do you think these rules net benefits?
I think this one certainly benefits the president, President Biden, because he should not have to have someone speaking over him with a live mic. Now, I am a bit skeptical that former President Trump will stop speaking when the mic goes off. In other words, will he continue to speak? And will that be distracting to President Biden, even though audience might not be able to hear, but will the president be able to hear someone who's trying to talk over him even without a live mic? And anyone who does any public speaking or is a teacher or professor knows that it's a little bit distracting and takes you off point. And if one is prone to gaffes, as we know President Biden can tend to be sometimes, that can be detrimental, I think, to him.
Well, to that point, Barbara, is really all this debate is about for Biden, not gaffing, not pausing for too long, not giving any appearance of weakness or a lack of mental acuity as he debates at 81 years old. Does it even matter what he says or only how he says it?
The message is always important as we look back through history. So, yes, he has to be clear on his message, but he also has to get the word out as clearly and concisely as he can. He shouldn't ramble. He should try to avoid gaffes. He should try to speak clearly. As Sandra Day O'Connor once said to my dad, who had some hearing issues, my dad went up to her and said, I can understand every word you say. And she said, that is because I speak and enunciate very clearly. So that's what I think the president needs to do and not have any stumbles or mumbles as he's speaking. And that's not going to be easy because he does have, as he's been very open about, the stuttering problem from years back, a lifelong problem. And as we all get a little bit older, we tend to have a few stumbles or mumbles. And that goes for, as we know, former President Trump, who just turned 78, and he has tended to ramble of late. So both of them have to be really careful about that.
Of course, while the age question has dogged President Biden, Donald Trump has been dogged by his myriad legal challenges, one of which we could have development in perhaps the very day of the debate, Barbara. We're still awaiting a handful of opinions from the Supreme Court, one of which is the question around presidential immunity that could dictate the timeline at which he could go to trial here in Washington in the Jack Smith case of election subversion. Is there any precedent in history in which you could have something like that dropping the day of a presidential debate?
I can't think of one offhand. Certainly, there have been events in the world that have been happening during debates. The first televised debate between Kennedy and Nixon in 1960, the height of the Cold War, but not anything like this, because we know it's the first time a former president has gone to a criminal trial and has been a convicted felon while on the stage and running for president again. So that's unprecedented. It wouldn't surprise me, as someone who served for a year at the court in the 1990s, if they might not hold off until after the debate to announce that decision, whatever it happens to be about presidential immunity.
Yeah, maybe we get an opinion day added on Friday. Barbara, before we let you go, just in our final moment here, there is the question of how much this ultimately will matter in the grand scheme of things. Looking back at history, do we consider presidential debates to be pivotal inflection points in any campaign?
Absolutely. And I would say, given this past week's passing of Willie Mays, and most people immediately, it came to mind his the catch, they called it. They didn't even have to say Willie Mays, the catch, running full speed, back to the infield, drops over his head, he catches the ball. If he had bobbled it, maybe it would have been remembered, maybe not. So I would say that for these presidential candidates and the incumbent president, they want to have clean catches, they want to hit home runs, maybe even a grand slam, no bobbles, no errors. And because that is what people remember, and it often has an impact on who wins or who loses the election.
All right, Barbara Perry, always great to talk to you. She is professor in presidential studies at the University of Virginia's Miller Center. Go Who's. Barbara, thank you so much for joining us here.
Thanks for listening to the Balance of Power podcast. Make sure to subscribe if you haven't already at Apple, Spotify, or wherever you get your podcasts. And you can find us live every weekday from Washington, D.C. at noontime Eastern at Bloomberg.com.